Hello there. The Supreme Court will start hearing the pro-Remain cases, claiming that the prorogation of Parliament in the run-up to Brexit is unlawful. The Supreme Court in London will be hearing two cases over the coming days, claiming that the prorogation of Parliament for 5 weeks in the run-up to Brexit was unlawful. One case is being brought by Gina Miller, with a 25-page submission appealing against an earlier High Court case that dismissed her claim. The other is being led by SNP MP Joanna Cherry, with a 93-page submission on the back of her success in the Edinburgh Court of Sessions, where 3 judges agreed with her that the prorogation was unlawful. And talking on BBC Radio Scotland this morning, Cherry said, "I think that Scotland's Supreme Court reached the right decision here for the right reasons, and I'm cautiously optimistic that at least a majority of the UK Supreme Court justices will follow." And Gina Miller issued a statement saying, "As with my first case, my Supreme Court case is about pushing back against what is clearly a dramatic overreach of executive power. This is an issue that cuts across the political divides and the arguments about the EU, and it has united Remainers and Leavers and people of all political complexions and none in opposition to it. The precedent Johnson will set if this is allowed to stand is terrifying. Any Prime Minister trying to push through a policy that is unpopular in the House and in the country at large would from now on simply be able to resort to prorogation. No one could ever have envisaged it being used in this way. This is a classic power grab. The reason for any prorogation was patently untrue, and since then, the refusal to come clean or provide any of the disclosures we have asked for has compounded the deception. It is my view, and the view of a great many others, that Mr Johnson has gone too far and put our parliamentary sovereignty and democracy in grave danger by his actions." But what she fails to include in her claims is that Parliament has had ample opportunity to follow its own internal procedures by calling for a vote of no confidence, or that it twice rejected the PM's offer of a general election. In effect, it is Parliament that has failed, not the government. The executive has been allowed by Parliament to do what it is doing. These are extremely important factors that cannot be overlooked. Our MPs had several chances to deal with the problem in the correct manner, but elected instead to attempt to use the courts in a cynically political manner. And also, as the government's defence says, the underlying claims are non-justiciable. Both long-standing authority and principle indicate that in some areas there are no judicial or manageable standards by reference to which the courts could assess the lawfulness of ministerial decisions. The exercise of this prerogative power concerning the length of prorogation is one of these areas. It is intrinsically one of high policy and politics, not law. For reasons of constitutional propriety, it is assigned to the executive, subject to control by Parliament through legislation and not the courts. And it also says, "The will of Parliament is expressed in legislation duly enacted by the Queen in Parliament. The appellant and the petitioners identify no primary legislation which the advice and the order in council contravene or would frustrate." And it also points out that Parliament could have legislated but did not legislate to ensure that Parliament continued to sit during the prorogation if that had been Parliament's wish. And, says the government's case, MPs had already proved they had sufficient time to legislate on Brexit, as proven by the Surrender Act. However, should the judiciary go along with this and rule against the Prime Minister, then I would argue that we've reached the point where voters should therefore have a direct say on who our judges are. If the judges want to involve themselves in politics, then they become politicians and must be held accountable at the ballot box, just like MPs as members of the legislature and just like mayors and police and crime commissioners as part of the executive. And finally, in a real act of hubris and hypocrisy, the former Tory Prime Minister, John Major, is giving evidence in the Gina Miller part of the hearing. One could not make this up. The man that prorogued Parliament back in the 1990s to stop a political debate in Parliament about cash for questions, with the effect that it was shut down for longer than this current prorogation. It just beggars belief. Anyway, what do you think? Please share and comment, and thank you for listening. Please do like and share this video, and also subscribe to my channel. And when subscribing, please do remember to press on the little bell next to the subscribe button. That way you'll get an alert every single time I put up a new video. Thank you very much for watching.